connecting contract provisions to the real-world transaction. In the previous section, you learned how a contract for sale is created through offer, acceptance, delivery, consideration, and signatures. You also saw how equitable title, contingencies, earnest money, and default shape the rights and obligations of buyers and sellers. In this section, you move one level deeper into the actual content of the sale contract. Instead of simply asking, "Do we have a contract?" you now ask, "What exactly does this contract say? And how does each clause affect my client?" Every sale contract is made up of provisions. Some are primary provisions that appear in almost every agreement, such as the parties, property description, price, financing, and closing dates. Others are secondary provisions, such as inspection clauses, association disclosures, environmental issues, and various addenda that apply only in certain situations. A successful real estate professional knows how to read these provisions, explain them in plain language, and recognize when a missing or poorly drafted clause could create risk for the client or the brokerage. Although there are many types of contracts of sale, the most common form that a new licensee will see is the residential purchase contract. This is the everyday document used to transfer ownership of homes and small residential properties. Commercial, land, new construction, foreclosure, and tax-deferred exchange agreements use similar concepts, but with additional complexity tailored to those transactions. By mastering residential contract provisions first, you build a strong foundation for understanding all other specialized agreements later in your career. Types of sale contracts and why they differ. Sale contracts come in many variations because not all properties and not all transactions are the same. A residential contract of sale is designed for owner-occupied homes and small residential buildings. It focuses on issues like inspection periods, home warranties, financing terms, and disclosures about condition. A commercial contract of sale may emphasize leases, income statements, environmental matters, zoning, and complex due diligence. A foreclosure contract of sale may include as-is language and strict timelines. Vacant land contracts may focus on surveys, soils, access, utilities, and development rights. Exchange agreements tie the transaction to Internal Revenue Code, Section 1031, and require cooperation with a qualified intermediary. Although the structure of these contracts may differ, many core provisions remain the same. Every contract still needs to identify the parties, the property, the price, the financing, the closing date, and the conditions that must be met before the transfer occurs. What changes is the level of detail and the specialized language in the secondary provisions. Primary provisions in a residential sale contract. The primary provisions are the backbone of the agreement. If these are incomplete or unclear, the entire transaction may be at risk. Parties, consideration, and property. The contract must clearly identify who is selling and who is buying. All sellers of record should be named, and all buyers who will appear on title should be identified. Parties must have legal capacity, meaning they are of legal age, mentally competent, and not under duress. The consideration is usually the buyer's promise to pay the purchase price in exchange for the seller's promise to convey title. The property section identifies what exactly is being sold. This includes the real property itself and often a list of improvements and items that will stay. Built-in features such as cabinets, attached lighting, and built-in appliances are typically considered fixtures and are presumed to transfer unless they are specifically excluded. Freestanding refrigerators, washers, and dryers, and personal decor are usually personal property that do not convey unless they are specifically included. A careful agent reviews this section with the parties and avoids assumptions. For example, if the buyer wants the garage refrigerator or a built-in sound system, those items should be clearly written into the contract. Legal description. The legal description precisely identifies the property, so that a surveyor or title company can locate it without confusion. Street addresses are helpful for navigation, but are not legally sufficient. A complete contract will use a lot and block description from a recorded subdivision plat, a meets and bounds description, or another legally recognized method. In practice, the legal description often comes from the previous deed or from preliminary title work. Price and terms. The price and terms clause pulls together the financial heart of the agreement. It states the purchase price and explains how that price will be paid. The contract should clearly show the amount of earnest money, the additional down payment at closing, and the anticipated loan amount or other financing sources. A good practice is to verify that all funds identified in the contract add up exactly to the total purchase price. When seller financing is involved, this section or a related addendum describes the loan amount, interest rate, payment schedule, term, and whether there is a balloon payment, prepayment privilege, or late charge. The more clearly these terms are written, the fewer surprises there will be later. From the seller's perspective, a higher down payment may suggest a stronger buyer with more stability and a better chance of closing. From the buyer's perspective, the payment and interest terms must be affordable and realistic. The agent's role is not to give legal or tax advice, but to help both sides understand the basic structure of what they are agreeing to. Loan approval and financing contingency. A financing contingency allows the buyer to cancel the contract and recover earnest money if the buyer cannot obtain the specified loan in time, despite using reasonable efforts. The contingency usually describes the type of loan, maximum interest rate, minimum term, and deadline for loan approval. For example, a buyer may make the agreement contingent on obtaining a 30-year fixed-rate loan, not to exceed a certain interest rate. If the lender later offers only a much higher rate, the buyer may have the right to cancel. The parties may also agree to extend the financing deadline if progress is being made and both sides still want to move forward. The key is that the contract should clearly state when the contingency expires and what happens if financing is not obtained. Earnest money deposit and escrow. Earnest money is the buyer's initial deposit held by a neutral third party and applied to the purchase price at closing. It shows seriousness and gives the seller some assurance that the buyer intends to perform. The contract states the amount, who will hold it, and when it must be deposited. In some cases, a small initial deposit is followed by an additional deposit within a short period, allowing the buyer time to move funds or complete initial due diligence. The escrow clause explains how the escrow agent will hold, apply, and release the funds. It also usually protects the escrow holder from liability as long as the holder follows the instructions in good faith. State license laws and brokerage policies strictly regulate who can hold escrow funds and how quickly they must be deposited into a trust account. Closing and possession. The closing and possession clause answers two practical questions. When will the deal close? And when will the buyer actually take possession? The closing date is the target day for signing documents, delivering funds, and recording the deed. Possession is often given upon recordation of the deed, but the parties may agree to earlier or later occupancy through post-possession or pre-possession agreements. Different parties view closing differently. To the lender, closing is when loan documents are signed, reviewed, and the loan is funded. To the title company, closing is when all documents are signed and ready for recording. To the real estate agent and the parties, closing usually means the moment that recording occurs and ownership legally changes. A well-drafted contract clarifies this and states what must happen for each party to be considered in compliance. Most contracts also require that if one side is not performing, the other side must send a written cure notice and allow a short cure period before declaring a breach and taking remedies. Conveyed interest and type of deed. This section states what interest the seller is conveying and which type of deed will be used. In a typical residential transaction, the seller conveys fee simple ownership by general warranty deed, subject to recorded easements, covenants, and restrictions. The contract may also state that the buyer accepts title subject to matters of record, such as utility easements, association rules, and property taxes. Title evidence. The seller promises to provide evidence of good title. Today, the most common form is a title insurance commitment, followed by a title insurance policy at closing. The title company examines public records for liens, judgments, unpaid taxes, easements, and other encumbrances. The buyer then has an opportunity to review the report and object to any unacceptable items. If serious title issues cannot be resolved, the buyer may have a right to cancel. Closing costs and prorations. The contract specifies which party will pay which closing costs. Often the seller pays for the owner's title policy and some document preparation fees, while the buyer pays lender-related charges, recording fees, and the cost of their loan policy. Property taxes, association dues, and some utilities are typically prorated as of the closing date, so that each party pays only for the time they own the property. Who pays specific costs is negotiable and may vary by region and by market conditions. In a buyer's market, sellers may agree to pay a portion of the buyer's closing expenses. In a seller's market, buyers may pay more of their own costs to make their offers stronger. Reviewing the draft settlement statement before closing helps ensure that costs match the contract and that neither party is caught off guard. Damage, destruction, and risk of loss. This clause explains what happens if the property is damaged before closing. The parties may agree that the seller remains responsible for the property and must repair damage up to a certain amount or credit the buyer at closing. If the damage is severe, the buyer may have the right to cancel or accept the property with an adjustment. For example, if a storm damages part of the roof after signing but before closing, the contract may require the seller to repair the roof or assign the insurance proceeds to the buyer. The key is that risk of loss must be clearly assigned so that everyone knows who bears responsibility if something unexpected happens. Default and remedies. The default clause describes what happens if either party fails to perform a material obligation after any required cure notice. If the buyer defaults, the seller may be entitled to keep the earnest money as liquidated damages and possibly pursue additional remedies if allowed by the contract. If the seller defaults, the buyer may be entitled to specific performance, damages, or cancellation with a refund of the earnest money. Agents should never decide on their own who is in default or where earnest money should go. If buyer and seller disagree, the escrow holder will usually hold the funds until the parties reach an agreement or a court or arbitration decision is obtained. Broker representation and commission. The contract identifies the listing and cooperating brokers, discloses agency relationships, and clarifies who is paying the commission. This section often confirms that the commission is earned when a ready, willing, and able buyer is produced on the terms of the listing, and it may address what happens if the transaction fails to close. Seller representations, property condition, and SPDS. Sellers make certain promises about the property and their authority to sell it. They usually warrant that there are no undisclosed liens that cannot be paid off at closing, and that they know of no undisclosed material defects. However, there are certain topics that the law specifically says do not have to be disclosed, such as deaths on the property, HIV status, or the presence of nearby registered sex offenders, unless other laws require disclosure. In Arizona and many other states, residential sellers complete a seller property disclosure statement, SPDS, or similar form. This document provides the buyer with a written summary of the property's condition, including roof, plumbing, electrical, heating and cooling, structural items, appliances, pool or spa, and other key systems. Sellers answer questions with yes, no, or unknown, and may add explanations as needed. The agent has a separate duty to disclose all known material facts, even if the seller does not disclose them. The SPDS does not replace the agent's obligation to disclose, and it does not replace the buyer's duty to inspect. Right of rescission related to disclosures. If certain required disclosures, such as property condition or association documents, are not provided within the timeframe set by law or by contract, the buyer may gain a right to cancel the contract within a certain period. This right usually expires at closing or occupancy. The buyer must follow procedures exactly to preserve this right, which often means giving written notice by a certain deadline. Secondary provisions in a sale contract. Beyond the core clauses, modern contracts include many secondary provisions that address specific risks or circumstances. These provisions give structure to inspections, associations, special property types, and federal or state laws. Inspections and due diligence. Inspection clauses confirm the buyer's right to inspect the property, usually within a defined inspection period. The buyer may hire licensed inspectors to evaluate the home's systems and structures and may also investigate environmental, zoning, and neighborhood factors. After reviewing inspection results, the buyer may request repairs, ask for a credit, or elect to cancel if the contract allows. The seller is generally not required to inspect for the buyer, except in special cases such as septic system inspections required by law or addendum. Handling inspection repair requests correctly requires careful reading of the contract and related forms. Owners' association and common interest disclosures. If the property is part of a homeowners association or condominium association, the contract usually requires the seller to disclose that fact, provide governing documents, and inform the buyer of regular assessments and any pending special assessments. Buyers need to understand the rules they will live under, including architectural controls, use restrictions, parking rules, and financial obligations. Survey and boundaries. In some transactions, especially land and rural property, the parties agree to obtain a survey to verify boundaries, easements, and encroachments. If the survey reveals issues such as a fence over the line or a driveway crossing a neighbor's property without an easement, the buyer may have options to object, negotiate, or cancel. Environmental hazards. Contracts often contain warnings about environmental hazards such as radon, mold, asbestos, underground storage tanks, or contaminated soil or water. The seller may disclose known hazards, but the buyer is encouraged to conduct independent investigations. Environmental issues can have serious health, legal, and financial implications. So this section reminds buyers that they bear responsibility for thorough due diligence. Compliance with laws and code violations. The seller may warrant that there are no undisclosed building code, zoning, or permit violations. If there are known violations or open permits, these should be disclosed, and the parties must decide who will correct them and when. Lenders and insurers may require certain corrections before closing. Due on sale and existing loans. If there are existing loans that will remain or be assumed, the contract may include a clause acknowledging that the lender may invoke a due on sale clause and call the loan due when the property is transferred. This protects each party by making clear that neither guarantees the lender's decision. Seller financing and legal disclosures. When seller financing is involved, there may be additional disclosures required by state and federal lending laws. The contract and any financing addendum help ensure that the arrangement complies with regulation and that both parties understand the risks and obligations. Rental property and tenants' rights. If the property is occupied by tenants, the contract addresses leases, deposits, and tenant rights. Many states require that leases survive the sale and that security deposits be transferred to the new owner. Buyers purchasing tenant-occupied property must be prepared to honor existing leases unless otherwise handled by agreement and applicable law. Government-backed financing conditions. When buyers use FHA or VA financing, Special clauses may state that the buyer is not obligated to complete the purchase or forfeit earnest money if the property does not appraise at or above the purchase price, according to FHA or VA standards. This protects buyers from being locked into paying more than the property is deemed worth under those programs. Floodplain and insurance. If the property lies in a special flood hazard area, the seller may be required to disclose that fact, and the buyer may be required to obtain flood insurance as a condition of certain loans. The contract can alert the buyer to check flood maps and insurance requirements before closing. Foreign seller withholding federal law requires that buyers withhold a portion of the purchase price and send it to the IRS when purchasing from certain foreign sellers. This helps ensure that capital gains taxes are paid. Contracts include language advising parties of this requirement and encouraging them to consult tax professionals to determine if the law applies. Tax-deferred exchange language. For income properties, one or both parties may wish to complete a tax-deferred exchange. The contract allows them to declare this intent and agree to cooperate with exchange procedures, such as allowing assignment to a qualified intermediary, as long as it does not increase the other party's costs or risks. Merger notices. Time is of the essence, and Counterpart's merger language states that the written contract contains the entire agreement between the parties, and that any prior verbal promises not written into the contract are not binding. Notices provisions explain how communication must be delivered and when it is deemed received. Time is of the essence. Language emphasizes that dates and deadlines are strict and can be changed only by written agreement. Counterpart's language allows the parties to sign separate copies that together form one fully executed agreement. Addenda and special attachments. Many transactions require one or more addenda that become part of the contract. Common examples include dual agency or limited representation consents, well and water addenda, septic and on-site wastewater addenda, airport or military airspace disclosures, mold disclosures, tenant lease summaries, and specialized pool, spa, or equipment forms. A particularly important federal addendum relates to LEED-based paint in properties built before 1978. Federal law requires sellers to provide an approved LEED hazard pamphlet, disclose known LEED hazards, provide any reports, and give buyers an opportunity to conduct a LEED-based paint inspection. The contract must include specific warning language and statements by both seller and buyer, acknowledging disclosure and receipt. Failure to comply can lead to substantial civil and even criminal penalties, as well as triple damages in lawsuits. The agent is responsible for ensuring that required addenda are prepared, signed, and retained, and that all mandatory disclosures are made before the buyer is obligated under the contract, or that the contract gives the buyer a clear right to cancel after late disclosures as allowed by law. Review summary. In this section, you explored the detailed provisions that make up a modern residential sale contract. You learned that while transaction types vary, every contract must identify the parties, the property, the price, and the terms of payment. You examined how loan approval clauses, earnest money, escrow, closing dates, conveyed interest, and title evidence work together to define the core structure of the agreement. You saw how closing costs and risk of loss are allocated, and how default and remedy provisions protect both buyer and seller. You also learned that secondary provisions provide the framework for inspections, association disclosures, surveys, environmental issues, compliance with law, rental occupancy, and government-backed financing requirements. You studied the role of special clauses, such as foreign seller withholding and tax-deferred exchange language, and how merger, notices, and time is of the essence. Provisions keep the agreement clear and enforceable. Finally, you saw how addenda and mandatory disclosures, including property condition forms, septic inspections, and LEED-based paint documents, become binding parts of the contract and carry significant legal consequences if ignored. By understanding these provisions, you increase your ability to guide clients confidently through the contract, anticipate issues before they arise, and work more effectively with lenders, title companies, inspectors, and attorneys. Discussion. Why is it important for an agent to understand both what is written in the contract and what is missing from it? Answer. An agent who understands what is included can explain rights and obligations to clients, and an agent who notices what is missing can help avoid disputes and risk by requesting appropriate addenda or clarifying language before problems arise. How do inspection and disclosure provisions work together to protect both buyer and seller? Answer. Disclosure provisions require the seller and agent to reveal known material facts, while inspection provisions give the buyer the chance to verify condition and discover issues the seller may not know about. Together, they create a more informed transaction and reduce the chance of later claims of misrepresentation. Why is the time is of the essence clause significant for contractual deadlines? Answer. When time is of the essence, dates and deadlines are not suggestions, but enforceable terms. Missing a deadline can be treated as a breach, so parties must act promptly or obtain written extensions to stay in compliance. How do federal laws, such as lead-based paint disclosure requirements, fit into a state-specific purchase contract? Answer. Federal laws overlay state forms and must be satisfied regardless of local practice. Purchase contracts incorporate these federal requirements through mandatory language and addenda, and agents must ensure compliance to protect clients and avoid substantial penalties. Closing remarks. Sale contract provisions are more than fine print. They are the operating system of the transaction. Each clause allocates risk, assigns responsibilities, and sets expectations. As you continue through this chapter and into more advanced topics, remember that the real estate professional who knows the contract in detail is the one clients trust the most. Reading the contract carefully, asking questions when in doubt, and staying current with updates will keep your practice strong, ethical, and legally sound.